Welcome to Legal Minds. My name is Samson Lwando. Today we are going to dive in the sphere of law of tort, and we are going to unlock the tort of defamation. What is defamation? Defamation, this is where a statement is made which injures or ruins the reputation of the person to whom it refers, which tends to lower him in the estimation of right-thinking members of society, generally, and in particular to be regarded with feelings of hatred, fear, dislike, and ridicule. So since we have defined this defamation, now what are the elements which need to be proved so that one can be held liable in the tort of defamation? The first element is, was the statement defamatory? And once you prove this element, it leads now to the second element. Did the defamatory statement refer to the plaintiff? And the last one, did the defamatory statement be published to a third person? So once you prove all these colleagues, then someone can be held liable in defamation. Now, defamation exists in two forms: libel and slander. What is libel? Libel, this is a statement which is published in permanent form. It can be either in writing, in news, broadcasting, films, and even tape recordings. What about slander? This is a statement which is published in spoken words. It is in visible or audible form, such as gestures or inaccurate sounds. Now, what is the difference between slander and libel or libel? Libel is actionable per se, but slander is not actionable per se. However, with slander, there are some exceptions in special circumstances where it can be actionable per se. Now, what are those? An imputation of a criminal offense punishable by imprisonment. That one, colleagues, it is actionable per se. No need to prove damage. The second one is an imputation against a female of adultery. That one also, colleagues, it is actionable per se. You say that someone is a slut, is adulterous. Huyu ni huli. Colleagues, that one is actionable per se. Another one is where an imputation that the plaintiff is suffering from an existing contagious disease, such a nature that it can cause the plaintiff to be excluded from society. And that one also is actionable per se. Another slander which is actionable per se is words spoken of the plaintiff that are calculated to disparage him in any office, profession, trade, or business. Another difference is that slander is a civil law. What about defamation? What about libel? Libel is both a tort and a criminal offense. When we look at section 191 of the Penal Code Act, chapter 87 of the Laws of Zambia, it provides there that defamation, now when it is existing in a form of libel, it is a criminal offense. So you will be prosecuted. Someone can be prosecuted of libel. What is the other difference? Slander is a civil law. It's only in tort where you can bring an action for slander. Let's look at another thing on defamation, which is called an innuendo. What is an innuendo? An innuendo, these are ways which are uttered with a hidden meaning. When we look at the case of Tole versus so as I was saying, the case of Tole versus Fry and Sons Limited, a 1931 case, Appeal Court 323. In this case, colleagues, I'll only give the brief facts, which says that the plaintiff was a well-known amateur golfer. The defendants published an advertisement without the plaintiff's consent, containing his picture and underneath the following words. The caddy to Tole said, "Oh sir, good shot. Sir, that ball, see it go. Sir, my word, how it flies like a carpet of flies. They are handy, they are good and priced low, sir." So the plaintiff brought an action for libel, alleging an innuendo. It was said that a person reading the advertisement would assume that the plaintiff had been paid for allowing the use of his name in it, that in consequence he had prostituted his amateur status as a golfer. It was held that the evidence showed that the advertisement was capable of his construction, and the plaintiff was awarded damages. An innuendo is proved by witnesses who know of the hidden meaning. So, meaning it can only be proved by the defendant himself, because he is the one who knows the meaning, any member from his class, or even neighbors. That's how an innuendo can be proved. So colleagues, you can read through this case and understand the principle which was shown in this case. So after all this, now, who can sue in defamation? Remember, colleagues, the essence of the tort of defamation is to protect the personality, the self-respect of a person. So, who can sue? Generally, defamation, the only person who can sue is the plaintiff. And in some circumstances, if the defamation is even affecting the family, so the family member can bring an action for defamation. But you cannot, remember this point, it's very important, colleagues. You cannot defame the whole class of people or the whole class of persons. I'll give you an example. Let's use the case of Jackson versus Stewart, where a judge said that no one can be sued if he says all lawyers are thieves, unless there is something pointing to the lawyer who wants to bring an action. Then that person can be sued. But if you just say all lawyers are thieves, no one will bring an action against you. No one will sue you. Now, what about a small group, a small class of persons, whereby the damage that any member from that group will suffer is equivalent to every person, to every member belonging to that group? Then, if it is a small class, a member from that group can sue you. So, colleagues, we have discussed the tort of defamation. Now, in my next video, we are going to discuss on the defenses and the remedies of defamation. Remember to subscribe to my channel and follow, like, even share. See you in the next video. Legal Minds.